Welcome to LexTalks Legal Topics Simplified, where we like to take complicated Indian legal concepts and make them a little easier to understand, especially for law students like you. Today we are going deep into ADR, Alternative Dispute Resolution in India. You might recognize it from a textbook chapter, but out here in the real world, ADR is a whole different game.
Yeah, it really is. ADR is changing how disputes are resolved in India, offering a pretty compelling alternative to the court system, which, let's face it, can be slow and expensive.
Well, before we get into all of that, it's interesting to me how something so important to modern law actually goes back centuries. Didn't ancient India have its own systems like panchayats, which were basically early forms of ADR?
Oh, absolutely. Panchayats, those community-based dispute resolution systems, they were like a cornerstone of ancient Indian society. It was all about negotiation, compromise, and keeping things harmonious. It wasn't about winning or losing. It was about finding a solution that worked for everyone in the community.
That's so different from how things are in courts today. So how did ADR evolve from that ancient tradition into the system we have now?
Well, the formal court system that the British introduced definitely changed things. But as India's economy grew and the legal stuff got more complicated, it became clear that courts just couldn't handle all the disputes on their own.
That makes sense. So this need for a more efficient system, along with the historical precedent of panchayats, that's what led to the ADR movement as we know it today.
Exactly. It's kind of like rediscovering a really useful tool from the past and adapting it to today's needs. And this revival, it was fueled by this desire for faster, cheaper ways to resolve disputes, and also this recognition that sometimes working together is just better than fighting.
Okay, I'm starting to see the big picture here, how ADR fits into the legal system. But if it's so great, why do we even need courts at all? Why not just use ADR for everything?
It's not really about getting rid of the courts. They are super important for upholding the law, setting precedents, and making sure there's justice. Think of it this way. Courts are like hospitals. They handle the really serious legal issues. ADR is more like a clinic you go to for specific types of disputes. It's more accessible.
So it's about picking the right tool for the job. You wouldn't go to the emergency room for a cold right.
Exactly. You got to assess the situation, what kind of dispute it is, and what you're hoping to achieve. Sometimes ADR just makes more sense, especially when you want to maintain relationships or you need a more tailored solution.
Now, I know there's not just one type of ADR. There are a bunch of different methods, and each one has its pros and cons. Can you break down the main types of ADR in India and how they are different?
Sure. Let's start with arbitration, probably the most well-known method. Basically, you have this neutral third party, an arbitrator, who acts like a private judge. They hear both sides and then make a decision that everyone has to follow. It's often used in complex commercial disputes where you need someone with specific expertise.
So it's more formal,
hmm
and the decision carries legal weight. What happens if one side doesn't like the arbitrator's decision? Can they appeal to a regular court?
Well, the option to appeal is very limited in arbitration, but it's not completely impossible. The key is to choose an arbitrator who is not only an expert, but is also neutral and respected, so the decision is likely to be fair from the get-go.
That makes sense. So what other ADR methods are out there?
Another one is conciliation. This is more collaborative. You've got a neutral third party called the conciliator who helps the parties communicate better and hopefully reach an agreement that works for everyone. It's often used in situations where it's important to keep the relationship intact, like family disputes or business partnerships.
So conciliation is about finding common ground and keeping things amicable, not just focusing on who's right or wrong legally. What about mediation? How's that different from conciliation?
Good question. They are similar, but there are key differences. Mediation is even less formal than conciliation. The mediator's main job is to make sure everyone communicates openly and understands each other. The goal is for them to come to their own agreement. In conciliation, the conciliator might be a bit more active in suggesting solutions.
Okay, I see the difference. It's about how formal it is and how much the neutral third party gets involved. But what about just plain old negotiation? Isn't that like the simplest form of ADR?
Absolutely. You could argue that all the other forms of ADR are basically just facilitated negotiation. Negotiation is just the two parties talking directly to each other, trying to work things out. It's usually the first step in any dispute resolution process, and it can be really effective when done right.
But not everyone is good at negotiating right. What happens if negotiations fail or someone feels pressured into a bad deal?
Well, that's where the other ADR methods can come in. If direct negotiation doesn't work, having a neutral third party, like a mediator or conciliator, can help level the playing field and guide them towards an agreement that is more balanced.
This is all really helpful. It seems like ADR gives you a whole toolkit of options to handle different disputes and get the results you want. But there's one ADR method I've heard of that I think is unique to India, Look Adalat.
Mhm.
What exactly are these people's courts and how do they fit in?
Look, adalats are really interesting. They're like these informal courts that provide a quick and easy way to resolve disputes, often led by retired judges or social activists. They put a lot of emphasis on compromise and reconciliation.
So it's kind of like combining the old panchayat system with a modern legal framework.
You could say that. Like adalats are known for being informal, fast, and affordable, which makes them really effective for resolving minor disputes, things like debt recovery or family matters.
This is giving me a much clearer understanding of all the different ADR methods available in India. But are there actual laws that govern all of this? Is there a legal framework that supports the whole ADR system?
Yes, there is. The backbone of ADR in India is the Arbitration and Conciliation Act of 1996. This act lays out the rules and procedures for the different methods, making sure everything is fair and transparent.
So the Act is like the rule book for the ADR game. But 1996, that was a while ago. Has it been updated to keep up with the times?
Good point. Like any good legal framework, it has to evolve. The 1996 Act has been amended, and courts have interpreted it to keep it relevant in our ever-changing legal landscape.
That makes sense.
But
So there's a lot more to unpack when it comes to the legal side of ADR in India.
there is. And we will dig into those details in the next part of our deep dive. We'll break down the key parts of the Arbitration and Conciliation Act, explore how court decisions have shaped it, and talk about some of the current debates and challenges surrounding ADR law in India.
This has been a fantastic overview. I'm looking forward to the next part. But for now, let's leave our listeners with this thought. ADR in India, it's more than just a legal concept. It's a powerful tool for resolving disputes effectively and making society a bit more harmonious.
It really is. And for future lawyers like yourselves, understanding and embracing ADR is not just beneficial, it's essential. Welcome back to our deep dive into ADR in India.
I'm excited to keep exploring this.
So let's get into some real-world examples of ADR in action.
I think that would be super helpful for our listeners, especially those law students who are probably wondering how all this theory actually works in practice.
Okay, so imagine a construction dispute, something that happens all the time in India with all the infrastructure development going on.
I can see it now. Two companies fighting over a project that's behind schedule costs are going through the roof, and it's all headed for a courtroom battle.
Exactly. That's a recipe for years of litigation, wasting time, money, and ruining the business relationship.
So how could ADR help in a situation like that?
Well, in this particular case, they decided to go with arbitration. They chose a neutral expert, someone who knew both construction law and engineering, to hear both sides. This arbitrator looked at contracts, technical specs, expert testimony, and in the end made a decision about who was responsible and how much compensation was owed.
So they avoided a long, drawn-out court case and got a decision from someone who actually understood the project.
Exactly. And that's what's so great about ADR. It allows for solutions that are tailored to the specific dispute. Now let's switch gears and think about a family-owned business facing a succession crisis. The siblings can't agree on who should take over.
Oh, that sounds like a recipe for disaster. A family feud that could destroy the business and tear the family apart.
It could, but in this case, they chose mediation. A skilled mediator helped them communicate their concerns, explore different options, and ultimately reach an agreement on how to share responsibilities and ownership.
So they saved the business and their family relationships.
Exactly. These are just a couple of examples, but ADR is being used all over India in all sorts of sectors. Banking and finance, intellectual property, even environmental conflicts.
That's really impressive. It shows how versatile ADR can be. But I have a question about enforceability. What happens if someone agrees to a settlement through ADR but then backs out? Is it just a gentleman's agreement or does it actually have legal weight?
That's a crucial point. The enforceability of an ADR agreement depends on the method used and the specifics of the agreement itself. For example, the Arbitration and Conciliation Act clearly states that an arbitral award is legally binding and can be enforced just like a court judgment.
So if one side tries to go back on their word, the other side can go to court and have the arbitral award enforced.
Exactly. The court will recognize the award as valid and won't usually interfere with the arbitration process.
That's good to know. What about agreements made through conciliation or mediation? Do they have the same legal standing?
Agreements reached through conciliation can also be made legally binding. The conciliator will often help draft a settlement agreement that can be filed with a court to make it official.
So it's like getting a seal of approval from the court to make sure the agreement is solid.
Yeah, that's a good way to put it. Mediation, though, is usually non-binding. But even then, the agreement reached through mediation can be used to create a legally binding contract.
So even if the mediation process itself isn't legally binding, the outcome can still lead to a legally enforceable agreement.
Precisely. It's all about understanding how each ADR method works and making sure the agreement is documented properly and, if needed, ratified by a court.
That makes sense. It seems like ADR is gaining popularity in India. But why isn't it even more widespread? Are there any obstacles holding it back?
That's a great question. While ADR is definitely on the rise, there are still a few hurdles. One is awareness. A lot of people, even lawyers, aren't fully aware of the benefits of ADR and all the different options available.
So we need to spread the word about ADR and show people how it can be a real alternative to litigation.
Exactly. Another challenge is finding qualified and experienced ADR practitioners, especially in specialized areas.
So it's not just about having the laws in place, but also having a network of skilled professionals who can guide people through the process.
Absolutely. And then there's the issue of enforcement. Even though the framework exists, there can be procedural complexities that make enforcing ADR agreements difficult sometimes.
So even though the legal basis is there, the practical implementation can still involve navigating a lot of bureaucracy.
That's right. But despite these challenges, the future of ADR in India looks promising. The government is promoting it, courts are becoming more supportive, and there's a growing understanding that ADR is vital for access to justice.
That's good to hear. But for those law students out there who are focused on getting that big law firm job, why should they care about ADR? How does it relate to their future careers?
This is where things get really interesting. The legal world is changing. Clients are demanding faster, more cost-effective, and more creative solutions to their problems. Lawyers who get ADR and can advise their clients on it will have a real advantage.
So it's not just about knowing the law, it's about understanding all the different ways to resolve disputes and helping clients choose the best approach.
Exactly. And think about the impact you can have as an ADR practitioner. You're not just settling disputes, you're helping people preserve relationships, protect businesses, and contribute to a more peaceful society.
That's a powerful way to look at it.
Yeah.
It sounds like ADR isn't just a legal tool, it's a way to make a real difference.
It really is. Now let's dive into the legal framework that underpins all of this.
Okay, you mentioned the Arbitration and Conciliation Act of 1996 earlier. What are some of the key elements of this act and how have they shaped ADR in India?
Well, the act is built around the idea of party autonomy. This means that the parties involved have the freedom to choose the ADR method that works best for them, select their neutral third party, and decide on the rules and procedures for the process.
So it's not a one-size-fits-all approach. ADR gives people the power to control their own dispute resolution.
Exactly. And this emphasis on party autonomy is a big reason why ADR is so appealing. It allows for flexibility, customization, and a sense of ownership.
Okay, party autonomy is key. What are some other important features of the 1996 Act?
The Act outlines the procedures for each ADR method, from appointing arbitrators to conducting hearings to issuing awards. This ensures that the process is fair, transparent, and consistent.
It's like a roadmap for ADR guiding the parties through every step.
That's a good analogy. The Act also deals with the crucial issue of enforcement. It makes it clear that arbitral awards are legally binding and can be enforced just like court judgments.
We talked about that earlier, and it's definitely a big plus for arbitration. What about conciliation and mediation agreements? How does the Act handle those?
The Act provides ways to make conciliation agreements legally binding. It also recognizes the importance of mediation in reaching settlements and encourages courts to refer cases to mediation when it's appropriate.
So even though the Act might not explicitly make mediation agreements binding, it creates a supportive environment for mediation and acknowledges its value.
Precisely. And to make sure that Indian ADR law is in line with global best practices, the Act incorporates parts of the UNC Side Troll Model Law, which is a widely recognized framework for international commercial arbitration.
That's smart. It helps ensure that ADR proceedings in India meet international standards. But I'm guessing the 1996 Act hasn't stayed exactly the same. Have there been any important changes or developments since it was first enacted?
Of course. Like any good legal framework, the Arbitration and Conciliation Act has evolved to keep up with the changing ADR landscape. For example, there have been amendments to limit how much courts can intervene in arbitration, streamline the process of appointing arbitrators, and clarify what public policy grounds can be used to challenge arbitral awards.
So these amendments are all about making the ADR system smoother, more effective, and more in line with global best practices.
Exactly. And in addition to legislative changes, there have also been significant court decisions that have influenced how the act is interpreted and applied. Courts are playing a vital role in clarifying things, resolving conflicting interpretations, and ensuring that the act promotes the growth of ADR in India.
That brings up a question about the current hot topics or debates in ADR law. Are there any trends or issues that are shaping the future of this field?
One of the most debated issues is enforcing foreign arbitral awards in India. As India engages more with the global economy, we're seeing more and more cross-border contracts that include arbitration clauses. Making sure these awards are recognized and enforced in India is crucial for maintaining India's reputation as a reliable place to do business.
So it's about making sure India's ADR system is in sync with the globalized business world. What other debates are going on?
There's ongoing discussion about how much courts should be involved in arbitration. Even though the Act aims to minimize court intervention, there are still some gray areas that can lead to litigation, which can undermine the efficiency of arbitration. Finding the right balance between judicial oversight and giving arbitrators the freedom to do their job is a constant challenge.
It's about finding that sweet spot where courts can step in if something goes seriously wrong,
Right.
but also allowing arbitrators to make decisions efficiently.
Exactly. Another hot topic is using technology in ADR. Online dispute resolution platforms are popping up, offering faster, cheaper, and more convenient ways to resolve disputes, especially for consumers and small businesses. But there are concerns about things like data security, privacy, and potential bias in these online platforms that need to be addressed.
That makes sense. It's great to use technology to our advantage, but we also have to be careful about the potential downsides. So what does all of this mean for aspiring lawyers? How can they prepare themselves to be effective ADR practitioners in this constantly evolving field?
The most important thing is to embrace a new way of thinking. ADR isn't just a specialized area of law, it's a core skill set that every lawyer should have. Aspiring lawyers need to develop their negotiation, mediation, and arbitration skills.
So it's not just about knowing the laws, it's about mastering the art of conflict resolution and being able to guide clients through the different ADR options.
Exactly, and never underestimate those soft skills. Communication, empathy, active listening, and problem solving. These are essential for any good ADR practitioner, no matter what method they're using.
Those skills are valuable in any area of law, really.
Absolutely. And for students who want to get some practical experience with ADR before they graduate, there are plenty of opportunities out there.
Oh, that's good to know. What kind of opportunities are we talking about?
A lot of law schools offer courses, workshops, and even moot court competitions focused on ADR. You can also join student-run ADR societies and look for internships or volunteer positions with ADR institutions or practitioners. The more exposure you get, the better.
This has been an incredibly insightful conversation. You've given us a lot to consider. But before we wrap up this part of our deep dive, do you have any final thoughts or advice for our listeners, especially those who are thinking about a career in ADR?
ADR is more than just resolving disputes. It's about creating a fairer, more equitable society. If you're passionate about finding creative solutions, if you believe in dialogue and collaboration, and if you want to make a real difference, then ADR might be the perfect path for you.
That's a powerful message. But before we move on, I have one more question that's been on my mind. You mentioned earlier how the Arbitration and Conciliation Act has been amended to limit court involvement in arbitration, which makes sense for efficiency's sake.
Yes, that's right.
But I'm curious, what are the specific grounds on which courts can intervene in arbitration? When do those limits on judicial involvement not apply?
That's a really insightful question. While the Act tries to protect the integrity of arbitration, there are limited circumstances where courts can step in. This usually happens when the very foundation of the arbitration process is in question, or when basic legal principles are violated.
So it's like having safety measures in place to make sure that courts can intervene if things go seriously wrong.
Well, exactly. For example, a court might intervene if there's evidence that the arbitration agreement itself is invalid, maybe because of fraud or coercion.
That makes sense. If the agreement that forms the basis of the arbitration is flawed, then the whole process is undermined. What other grounds for intervention are there?
Another reason could be if there's a problem with the composition of the arbitral tribunal, like if there's bias or a conflict of interest on the part of an arbitrator.
So if there are doubts about the impartiality of the decision makers, the court can step in to protect the integrity of the process.
Precisely. And a court might also intervene if the arbitration procedure didn't follow basic principles of natural justice, like denying a party the right to be heard or to present evidence.
So it's not just about the final outcomes, it's about making sure the process itself is fair and just.
Exactly. And lastly, a court might intervene if the arbitral award goes against public policy.
Public policy can be a pretty broad and subjective concept. Can you elaborate on that a bit?
You're right. Courts have been very careful in defining public policy in this context. They usually limit it to situations where enforcing the award would violate fundamental values of Indian law or morality.
So it's not about disagreeing with the arbitrator's decision. It's about making sure the award doesn't clash with the core principles of the legal system.
Exactly. These limited grounds for judicial intervention are a critical part of the ADR framework. They help ensure fairness while still respecting the autonomy of the arbitral tribunal.
That really clears things up. It's all about finding that balance between ensuring fairness and maintaining efficiency.
Exactly. Aspiring lawyers need to be able to explain the benefits of ADR to their clients, but they also need to make them aware of the potential drawbacks and limitations so they can make informed decisions.
This has been incredibly enlightening. We've covered a lot of ground today.
We have.
And unfortunately, we'll have to pause our deep dive here for now. But we'll pick up the conversation in the final part of our episode, where we'll explore some more specialized applications of ADR and talk about what the future holds for this dynamic field. Welcome back to our deep dive into ADR in India.
It's good to be back.
In the previous parts, we talked about the history concept, growth benefits, key laws, and the various methods of ADR.
Yes, we did.
Now I'm really interested in seeing how ADR is being used in specific sectors.
Great idea. Let's start with a sector that's booming in India. E-commerce.
Yeah, with online transactions growing so fast, I can imagine there are more and more disputes between buyers and sellers.
You're absolutely right. Disputes about product quality, delivery delays, refunds, they're becoming super common. And traditional litigation would just be too slow and expensive to deal with all of these.
So ADR is providing a more efficient way to handle them.
Exactly. A lot of e-commerce platforms now have their own built-in dispute resolution systems. They often use a mix of online mediation and arbitration. And these systems are designed to be easy to use, accessible, and quick.
That's so convenient for both buyers and sellers. It's like having an online judge right there on the platform.
That's a great way to put it. Another sector where ADR is making a big difference is intellectual property rights.
Yeah, as India becomes a global innovation hub, I can see how disputes over patents, trademarks, and copyrights would be increasing.
Exactly. And these disputes often involve complex technical stuff that requires specific knowledge.
So ADR allows the parties to choose arbitrators who are experts in these areas instead of relying on generalist judges.
Exactly. Having that specialized knowledge can lead to more accurate and fair outcomes. Now let's shift gears and look at another area where ADR is proving really valuable: environmental disputes.
As India tries to balance economic growth with environmental protection, I'm sure conflicts are bound to arise.
They definitely do. And ADR is helping to find solutions that work for industry communities and environmental groups.
So ADR is facilitating those conversations and helping everyone come to a consensus.
Exactly. It's about finding ways to achieve sustainable development without getting bogged down in long legal battles.
This all sounds really positive, but are there any situations where ADR might not be the best approach or might not work very well?
That's a good question. While ADR offers a lot of advantages, it's not a magic bullet. For example, if a dispute involves some really complicated legal questions that need a clear precedent from a court, traditional litigation might be the better option.
So if you were trying to establish a legal principle that will apply to future cases,
Yeah.
ADR might not be the right forum for that.
Right. ADR is generally not appropriate for disputes involving serious criminal allegations either.
Yeah, in those cases, the criminal justice system has to run its course.
Absolutely. And if one of the parties isn't willing to participate in good faith, or if there's a big power imbalance, ADR might not be very effective.
So ADR needs everyone to be committed to finding a solution that works for everyone.
Exactly. It's important to understand both the pros and cons of ADR and choose the dispute resolution method that makes the most sense for the specific situation.
This leads us to a bigger question.
Right.
What's next for ADR in India?
Well, I believe ADR has a very bright future in India.
What makes you so optimistic?
There are several reasons. First, the Indian government is actively promoting ADR and including it in various policy initiatives. Courts are also referring more cases to mediation and encouraging parties to explore ADR options.
That's encouraging.
But maybe most importantly, there's a growing awareness among people and businesses that ADR can be a more effective and empowering way to resolve disputes.
So it's not just about legal frameworks and court referrals. It's also about a change in how people think about conflict resolution.
Exactly. As India's economy keeps growing and legal issues become more complex, the need for efficient, accessible, and flexible dispute resolution mechanisms is only going to increase.
And ADR is well suited to meet that need.
Absolutely. ADR isn't just a supplement to the traditional court system, it's a crucial part of a strong and fair justice system.
But what can be done to make the ADR system even stronger in India?
One important area is building a solid foundation for ADR. This includes setting up more ADR institutions, training more qualified practitioners, and developing clear procedures and guidelines for different methods.
So it's about creating an environment where ADR can really flourish.
Exactly. Another key area is raising awareness. We need to educate the public businesses and even legal professionals about the benefits of ADR, address any misconceptions, and showcase successful examples.
Education and awareness are vital for getting more people to embrace ADR.
Absolutely. And lastly, we need to keep improving the legal framework for ADR, making sure it strikes the right balance between party autonomy and judicial oversight, between flexibility and enforceability.
It seems like the future of ADR in India depends on a combination of things: legal frameworks, institutional support, and a shift in cultural attitudes towards resolving disputes.
You've hit the nail on the head.
This has been a truly insightful deep dive into ADR in India. I've learned so much about its history, different methods, legal framework applications across various sectors, and future possibilities.
I've enjoyed sharing my insights with you.
I'm sure our listeners, especially those studying law, will find this information really valuable as they embark on their legal careers.
I hope so. Remember, ADR is not just about ending conflicts. It's about giving people a voice, encouraging cooperation, and creating a more just and harmonious society.
Yeah, it's a powerful thought to leave us with. Thank you for joining us on this deep dive into ADR in India.
My pleasure.
We hope you found it informative and thought-provoking. Don't forget to subscribe to LexTalks for more legal insights. Till next time.